0.0000001, you will immediately report to jail and you will sit the whole sentence. No good time, no Huber. I do not take, I was near rubbing alcohol. I do not take, I ate bang bang shrimp. I do not take that I ate tiramisu and it was made with real alcohol. Now, again, you understand that I'm not bound to follow any recommendation, and that would include following the IDIP guidelines.
Yes.
I could sentence you all the way up to the maximum possible penalty, again, if I thought it was warranted. You understand that?
Yes.
Do you have any questions for your attorney or the court before we proceed?
Right.
And that's all kinds of fun today. Okay.
Sorry about that.
All right. So you understand I could sentence you to the maximum penalty?
Yes.
Okay. Any questions?
Just one. It's just kind of a math question. I just want to know if it's fictional or a fact.
Math is usually not fiction. Why,
Yeah.
it's math.
And yeah, so I'd just like to be explained, like, how the math works. So I'm pretty good at math.
You want me to get a math professor in here to explain it? Because I'm not a mathematician.
That's what he said.
That he's not a mathematician because he's not, because quite honestly, we go to law school, so we don't have to do math, but we have to do math in our job. What's your question?
Just to know if this is fictional or factual.
I don't know what this is.
Would you like me to?
No, what is this, Mr. Keene?
Your Honor, I think it's explained. The issue, and it's been up with Ms. Anderson, is he had a question about the grams per 100 milliliters.
Dude,
and
that's a scientific question. You can call up the scientists or the lab analysts that do that. I'm not in charge of that. And the legislature makes up the laws. I'm in charge of following and enforcing the laws.
Okay.
So what's your question? You think that you were below the limit, above the limit, beyond the limit, how they came up with the limit?
According to this, I was not above.
Okay, and that's like a AI chatbot thing, right?
Yeah. So
Yeah.
maybe it's wrong.
Yeah, it is.
An AI chatbot?
But
Are we using artificial intelligence?
it's just that I was measured in thousands, and the law goes by hundreds.
You can have a trial if you want.
I am so great to have a trial. I love having trials, especially when the lab analyst comes, and especially when then it completely opens up to the maximum penalties. That's great and fine with me. Is that what you wish to do, and have a lab analyst up here to explain all of the scientific reasoning behind the calculations and behind their testing?
Just take me to jail.
Okay, I think that's his way of saying he's not rushing to press the point, Your Honor.
All right. Okay. So now, did you review the criminal complaint with your attorney? And it has all of those facts that says what happened that day from the officer's perspective and from your perspective, because you said, I only had 1 or 2 beers, which we know isn't factually true.
No, I had 0. I had drinking the night before.
So then you drink a lot more than 1 or 2 beers the night before.
I had a six pack of 16 ounces and a 16-ounce.
And yet you blew a .221, allegedly in the criminal complaint.
Yeah, and that's what I'm saying is that 221 is thousands, not hundreds.
Oh, Mr. Lamprecht, it's .08 in Wisconsin to be legally drunk. And for 1 or 2 beers or a 6-pack or whatever you said the night before, unless you are a chronic alcoholic who drinks all the time, you won't wake up the next morning to blow a .221. It's impossible.
Exactly.
But you did. And we have lab, right, Mr. Renicky?
We have a lab.
What does lab say? Where they tested it with scientific stuff.
I didn't mean to put you in a bad mood.
0.19. You did by starting by being late.
I
Okay.
apologize.
You're not supposed to be late to court. Okay. You're supposed to be here early so you can meet with your attorney. And quite honestly, and it's taken you months and 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 months to do the IDIP program. I gave you yet another chance. And now you're here debating
I'm just saying,
science.
anytime you put a numeral behind the decimal, Like one numeral behind the decimal is a tenth. Two numerals behind a decimal is 100th.
Yep.
Three numerals behind a decimal is 1,000th.
Yep, I know math.
Okay, and 1,000th is 10 times less than 100th.
Well, let's cut that off, okay? You blew a 0.22 with a PBT.
221.
Or 0.221, okay? So let's say you will cut off the one, because that's what math does. You get to cut off certain things. So you were 0.22. We'll give you the benefit of the doubt. No more with that one, that thousandth, gone. So you blew a 0.22. But lab came back and said, guess what? We ran his blood, which is more accurate. And it gave us a better truth of what happened. And it was 0.19. It's 0.08 in Wisconsin to be legally intoxicated and operate. So you get it now? You understand now?
I don't understand how 1,000th is 100.
I cut it off. I agree with, I'll give you the benefit. I cut that off. It's 0.22. It's 0.22.
No, if there's three numerals, because if it was point,
Mr. Renicky, I'd love to have a jury trial because it sounds like he doesn't understand the science and he wants to have a lab analyst here. Is that right, Mr. Keene? Is that what I'm hearing? He wants to have a jury trial because we can facilitate that next week.
I'm just saying what math.
I had a jury trial come up, not next week, the week after. We can get a jury trial. Is that what you want? You want to fight that issue of this extra thousandth in the decimal point?
It's not an extra thousandth, though. It's 1,000th or it's not.
Okay, it's 1,000th or it's not.
Yeah.
You want to go to trial over that and have the lab analyst explain it? Because I'm going to tell you, she is far smarter than I am when it comes to science and to explain it to you. Then maybe you'll be able to understand. You won't be able to ask her questions.
How about this? Can I just go to jail and I'll give you this copy?
I don't need the copy.
Okay, and then so give me the knowledge because I like math and
Here's what you can do to gain knowledge. Call up a lab analyst, have them explain it to you. Because that's what happens in a jury trial. And I hear it. It goes on for hours.
I'm not trying to piss you off. Just take me to jail. I'm fine with that. I have the money finally at the last moment. You've been very giving, lenient with me and gave me extensions. You're fair. And I'm here. And I'll go to jail, get out. I got a job.
All right. So are you admitting that you at least blew over a 0.08 or at least 0.08, at least blood alcohol content was in your blood at the bare minimum?
I agree that I blew a 0.221 and I agree that my blood alcohol was at 0.190.
Okay. All right.
I agree with those.
And do you agree that you operated or drove a motor vehicle in that state?
I agree to that, yes.
All right. Mr. Keene, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats to you, Mr. Lamprecht? Any promises for you to plead guilty to this charge? Has anybody promised you anything? Hey, we're going to give you $1 million if you plead guilty. Or we're going to give you some kind of benefit if you plead guilty, other than this offer of guidelines.
The only thing that I've been told was that I can get out, keep my job, keep my place, and keep my things.
Okay, so that's not a promise. Anyone threaten you anything? I'm going to beat you up. I'm going to take a gun. I'm going to take a knife. Anybody threaten to hurt you or anything?
None of those.
Okay. You're pleading guilty with a full understanding of what you're doing here today?
Yes, I'm pleading guilty to blowing a 0.221 and having a blood alcohol content of 0.190.
All right. And you're pleading guilty voluntarily?
Yes.
Does anyone or are you satisfied with your attorney's services?
I guess 5 out of 10.
5 out of 10. Has he done a good job in the fact that he's looked to see if you had defenses? Because I'm going to tell you, your argument here is crap. I don't say crap in court. It's crap.
I'm just trying to conversate. I'm not trying to argue.
This isn't a conversate
time.
Okay. This isn't a time to conversate.
Okay.
This is a plea and sentencing in which you showed up to court 18 minutes late.
Okay. I forgot my money. I apologize.
Has your attorney talked to you about the case?
Yes.
And has he looked at everything and discussed with you everything that he's seen in discovery.
Except for my one question.
All right, because he's not a scientist, but he said you can figure that out. Talk to a scientist, right?
I don't know any.
Mr. Keen, you said that's not a defense, correct?
And yes, and we have discussed that in basic math and other things along with it extensively.
All right, okay. You have any? No. All right, so based on this, the OWI third, count one, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count one. Count two will be merged and dismissed with count one. A judgment of conviction will be entered today. Mr. Renicky, argument, please.
This is kind of amazing, but in any event, this is an OWI. There was bad driving, but no accident. As the court is aware, it's a .19 BAC. This is his third OWI. He did complete the IDIP program. He still has to, at least at the time of my letter from Tessa Anderson, he had just dropped off the last $200 to complete the IDIP. But he needs to come up with a down payment for the electronic monitor as well as the booking fee. He was booked and released, so he has not set the 48 hours. Because of the IDIP completion and consistent with the plea agreement, we would ask the court to follow the IDIP guidelines for the 1-9 on a third offense, which I believe is $1,911 for fines and costs. It's a blood draw, so there'd be a $10 blood draw, 45 days of jail, 24 months of ignition interlock, 75 hours of community service, and 24 months of revocation.
Mr. Keen.
Yes, sir. I think this agreement recognizes both that alcohol use is an issue in the community. It has provided some rehabilitation needs because he has done some community service to, deal with the harm to community. Although again, no accidents happened. He was, for the period of the IDIP, which is longer than normally, done by the court by a substantial factor, had to blow into a tube and verify that he was not under the influence of alcohol. He also, as with an OWI 3, he would have a blood alcohol content restriction of 0.02, which means, I'd be careful about even non-alcohol alcohol, because 0.02 is nothing for the next 2 years. And it does have the future deterrence because any OWIs after this are felonies with a minimum of 1.5 years in the Wisconsin state prison system, because OWI 3 is the last one. It's still considered a misdemeanor. So I think that although it was a painful process to get here, the court should stick with the agreement because, it a pain, but Mr. Lamprecht has met the terms of the IDIP, albeit not in the normally prescribed time. The agreement does serve the goals of trying to get pre-sentencing rehabilitation done, and there's substantial deterrence to protect the community's interest because of just the fact that it's an OWI 3 and the ignition interlock provides that for 2 years, plus the substantially greater penalties on any future sentences. So I would ask the court to stick with the agreement despite the, less than beneficial behaviors at times exhibited by Mr. Lamprecht.
Thank you. Mr. Lamprecht, anything you want to add or say to the court?
Nothing that I haven't already.
Well, what are you doing employment-wise and stuff that you're trying to help the community?
Yeah, I have a job.
Okay.
He has a job, he has a life, he
Yeah.
is there waiting for him after he's done here today, which is all a positive thing. It's all about rehabilitation. OWIs are very serious. I don't make the law. The legislature makes the law. I don't determine the science. The lab analysts who go to school for years and years and years and years and years, the lab analysts, they learn science and they learn how to read scientific data. So they are the smarter ones in the OWI matters. I know the law, I see the law, I read the law, I enforce the law, I ensure that that the community is protected in certain ways. OWI is again serious. You're putting yourself at risk, you're putting others at risk. The fact that you blew a .221, had blood alcohol content from blood at 0.19 is serious, especially given.
190. Sorry for interrupting.
Don't interrupt me again. You interrupt me again and I will hold you in contempt. I will hold you in contempt and I will ensure that you have more jail time than what's being sentenced here today. All right?
I like you and you're a fair judge. I'm not trying to piss you
Then
off at all.
stop talking.
Okay.
I need to ensure that the public is going to be protected. And that means to ensure that you've learned a lesson, you're rehabilitating, you've done the IDIP program. That's a positive program. It's taking you more than most to do that program, but you've at least completed the program, which is positive. You're going to have the ability to get your license back or get an occupational prior to the end of your revocation. Your attorney is very correct. The next OWI will be a felony. The one after that is mandatory minimum prison sentences. So it's very important that you figured it out now and that you're not going to engage in this type of behavior before or again. What I will do is I will follow the IDIP guidelines. Despite all of the issues in this case, I'm going to follow the IDIP guidelines. I'm going to assess $1,911 in fines and fees with an additional $10 blood draw fee, 45 days in jail, 24 months of ignition interlock device to be placed on any vehicle you drive. Doesn't mean you need to own that vehicle. If you're going to borrow your mother's vehicle to go down the street to the gas station, it must have the IDIP in it or the interlock in it, or you may not drive the vehicle. 24 months of revocation of driver's license, OWI assessment and driver safety plan, 75 hours of community service. If you wish to convert the 75 hours to additional jail time, you can do so. Talk to Ms. Anderson. She will ensure that the court gets a letter and you must pay every, it's an additional 8 hours of community service for 1 day of jail time. So it's an additional $18 a day that you would need to pay if you wish to convert any community service to additional jail time. You must report immediately report to jail. And that means that you will have to go sit 48 consecutive hours before you are eligible to be released on monitor. I'm going to tell you, this is where I'm going to be very clear with you, Mr. Lamprecht. I take no excuse. If you are going to be released on monitor, you must prepay at least 30 days in advance. If you are even 1 day late on payment for a 30-day advance, you must sit in jail. You don't get additional time. This is where I'm very serious. You blow even a .0000001 with anything with alcohol, .00001, that's a violation to me. You will be immediately terminated off of the monitor. You will immediately report to jail and you will sit the whole sentence, no good time, no Huber. I was near rubbing alcohol. I ate bang bang shrimp. I do not take that I ate tiramisu and it was made with real alcohol. Okay, I take no excuse. It is an immediate report, no good time, no Huber. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, a civil judgment will be entered against you. You will also need to, you could sit up to 6 months in jail for that. I make sure that the money is paid. If it's not paid, it may result in an additional 6 months of incarceration. So ensure that you make your payments. When are you going to pay off the entire $1,921?
I have enough for the monitoring and the jail fee at this time.
$150 a month you must start paying. I'll give you August 1st. I'll give you a little stay until August 1st, but then in August, you must make your first payment at $150 a month until that's paid off in full. Again, if you miss one payment, a warrant will be issued. You could sit up to 6 months in jail. It's very important that you make sure you pay 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. Report to jail immediately. Your DNA is ordered. They will take that. You can request it be expunged through a written letter to the Department of Justice. Mr. Renicky, what am I missing?
I think you've covered it. Thank you.
Mr. Keen?
You aren't not on that, but I did have a couple of items. One is, and which didn't get filled out, if he has the opportunity while he's sitting to fill out the petition for half price ignition airlock, if he qualifies, can he submit that to the court?
He can. I'm not going to give him time to do it. He's going to go report to jail.
Right, understood that, understand. And then the other item is one I filed way back in October, and you at the time rejected the proposed order and what, and so could you?
To waive fines and fees?
Well, it's to reduce the fees by the amount paid for the IDI, the alcohol assessment and the driver safety plan if they're provided to the court. And the 10th Judicial District, I will admit it varies by court. Like Douglas County does it, Barron has it.
Want me to waive?
What it would be is like, he has that fine of 1,900 and some bucks. What the statute allows is, if the court grants it, is to have the amount of the fine reduced by Mr. Lampick providing receipts to the court for the assessment
I'm
and driver
denying
safety.
that.
Fund.
No,
Okay.
I don't do that. And so you can understand, there's not much that can be waived. There's a lot of mandatory surcharges in there. And when you go through it, really, because I've had really poor people that have asked, can I just do community service with the ones that that cannot be waived? There's not really that many that can be waived. And plus, this is a punishment. That's part of the punishment. And so I see it as a punishment, and that's why the legislature has increased, and they continue to increase these fines and fees. It's to say, don't do it again, don't do it again, don't do it again. And so, no, I'm denying that motion.
Yes, sir.
Thank you. Ms. Atkinson. Ensure that he gets and reports to jail immediately. You may.
Can I make a couple phone calls?
That's up to the jail.
Yeah.
In the matter 23 CF 92 26. Nope, that's it. 92 State of Wisconsin versus Joseph, also known as Josie Smith. Josie, you may come up here and have a seat. Josie appears in person in custody with counsel Joel Feliski. The state appears through District Attorney Kevin Schmidt in person. We're set for a sentencing portion of this case. There's been an extensive, significant delay in this matter from the beginning to finally the end. Josie, there were multiple times and where I would define it as you absconded. You failed to appear for court for very lengthy periods of time. A lot of money had been forfeited to the county, which would be at your expense because it was a lot of cash. I'm not even sure if we have any cash still posted, but the clerk will let me know during the process of this hearing. You pled guilty way back on November 20th, 2025. The court ordered a pre-sentence investigation report for those two felonies. One is a second-degree recklessly endangering safety, Class G felony, and the other felony is vehicle operator, flee or elude an officer. The court has received and reviewed the pre-sentence investigation report. Again, that took a lot of time and effort due to the fact that it was ordered. They weren't able to get a hold of you. You didn't contact them. You absconded. And that happened at least on 2 occasions that I can recall. Mr. Schmidt, did you receive a copy of the pre-sentence investigation report?
I received it. I reviewed it. I have no corrections.
Did you receive a copy of the sentencing memorandum filed by defense?
Yes.
Okay, Mr. Feliski, did you receive and review the PSI?
That is correct, Your Honor. I reviewed it with Josie, and we do not have any corrections to make at this time.
All right. Josie, did your attorney go over that document, this one right here, this big, thick document with you thoroughly?
Yes.
And you could not find any material errors that would need to be corrected?
No.
Okay. All right. So I'm going to start with you, Mr. Schmidt, sentencing recommendation and argument.
Thank you. State's going to be recommending the court follow the Department of Corrections recommendation. The court should order 1.5 in, 2 out on the fleeing, should order 3 in, 4 out on the reckless. Those counts should be concurrent to each other because they were part and parcel of the same action or series of acts on the same day. They described the same conduct. They should be consecutive to any other sentence in Wisconsin or Minnesota because they are distinct acts in a distinct state. I start first with explaining why probation should be rejected. First off, this is Smith committing their third fleeing offense. They have one prior criminal conviction for it and one prior adjudication of delinquency for it. This offense was committed while on supervision for one of the fleeing offenses. Probation is a consequence for a crime that you're already on probation for, and you do it again it's nonsensical. That is the clearest sign that probation unduly depreciates the seriousness of the offense. Furthermore, Smith's history clearly demonstrates that they're just not amenable to supervision at all. At age 25, Smith has 10 prior criminal convictions, counting these 2 today, and 9 prior juvenile adjudications for crime. That's 19 convictions or adjudications over only 13 years. When you go down and read through that sentencing, what do you see? In the criminal cases, you see probation ordered every single time, 8 times convicted prior to today. Smith was given 8 orders of probation. Smith has persuaded adult courts to place them on probation every single time. 8 times Smith has been ordered, to work with agents, to deal with substance abuse, to deal with mental health, to deal with cognitive issues. 8 times it's failed. CCAP and MCRO are useful in figuring out why. And that's because Smith simply doesn't participate unless they're physically forced to. MCRO and CCAP show countless failed court appearances while the cases are ongoing and probation violations once they've concluded. Smith's own stated reason in our case for fleeing the police was to avoid those consequences. Smith had 3 different Minnesota warrants out for her arrest when this fleeing happened. In our own case, even, it took 4 warrants across 3 years to force Smith here to this table at this moment. The court gave Smith a big leap of faith when it allowed her to stay out and go to that treatment facility while waiting for the PSI. And Smith demonstrated why she's not amenable to supervision when she didn't come back when she absconded. As a result, probation is not appropriate for this offender. There's no reason to think that she will comply when there's a decade of history telling us otherwise. Smith needs treatment, and this needs to happen in a confined setting. I find it strange that Smith related to the PSI writer that they didn't believe incarceration is effective at changing people's behavior because, like I said, Smith's effectively been on some form of supervision for 13 years, going way back into her childhood. She's not been given incarceration. So to conclude it's not effective when what you're asking for has itself not been effective doesn't make a ton of sense. It should be no wonder that Smith has continued unabated in her behavior because she's simply not been held accountable. The only time she's gotten incarceration, it's been as a revocation or a DOC action for noncompliance. The PSI talks about some of Smith's challenges, her criminogenic needs. Smith has a family that has a lot of members who have been involved in criminal activity. She talks about that in her own, how that's affected her own struggles in the PSI. She grew up with said family and said that they made drugs available to her, causing early life addiction issues that continue to this day. She has mental health struggles. At 25, she's seemingly not ever worked a job ever. These are all things that can and should be addressed when considering the character of the offender. These are obvious things that need to be dealt with to deal with the idle hands issue that I think is a cause of a lot of this crime. Those issues should be dealt with though in prison though, because prison does have resources that Smith hasn't tried. Being on supervision one way or another for 13 years in Minnesota, where they have far more programs than us, she's exhausted everything. Even beyond that though, there's profound need for deterrence and punishment in this case. To me, the number one thing I look at when I'm reading a PSI is the offender's version of their prior history. What a person thinks about what they've done in the past and how they talk about it now in the present tells you a lot about them. It tells you what is important enough to them to remember that they talk about later, how it affected them. This tells you about cognition. It tells you about criminal thinking. It tells you about consciousness of guilt. It tells you how they're going to think about this case in 5 years and 10 years. To the defendant's credit, she does appear to take responsibility for it without making excuses of her adult criminal history. That's more than we can say for a lot of the people that come before this court. However, the defendant claims they don't remember any of the incidents that happened when they were a juvenile. I find this concerning for two reasons. One, that juvenile record was not that long ago. This defendant's only 25 years old. It was not, it was too long ago is not a viable excuse for not remembering. However, the main reason I'm really concerned about this is because Smith's juvenile record, I'm sure the court's noticed, is categorically different from her adult record in that the juvenile record is mostly victim cases. It's assaults, it's thefts, it's crime damage, it's arson, offenses where those should be the ones you do remember. Those are the ones you hurt somebody either physically or financially or emotionally. Those are the ones where if you have empathy and consciousness of guilt, you relate back, wow, I did this terrible thing to that person, that hurts, I want to change who I am as a person. Not these fleeings or a simple possession or something like that. There's indication in multiple places in the PSI that Smith would want to address issues and change herself, but none of those really seem to be in connection with remorse or feeling bad. They seem to be connected to improving her own experience in her own life. Looking at page 10 in the PSI, the defendant says she expresses remorse, but only talks about wanting to achieve better outcomes in her own life in terms of rehabilitation. To that end, what is left when you have a person who's been supervised constantly through various forms of adult and child supervision over a decade, and it continues to fail? You do incarceration. That's what Minnesota finally did after many years in their most recent probation revocations. According to the PSI, if the court orders incarceration up front in this case, it'd be the first time ever that any court has done so in Smith's life. The only time she's ever gotten any sentences, like I said, been on the revocation or been on some sort of a hold while waiting for treatment or something like that. It'll only be the second time she's ever been ordered to prison. It is unfortunate that Smith's been allowed to accumulate this kind of history in Minnesota. It would defy the sentencing factors in Wisconsin for a person to accumulate this many convictions and not get any incarceration. And the Cleary-Gallion factors wouldn't allow it. These cases and what these convictions are for and the non-appearances all reflect a deep cognition issue that doesn't really get addressed in the defense sentencing memorandum at all. The defense sentencing memorandum really just talks about substance abuse and another issue, which I'll get to later. When treatment fails, when cognition is contaminated with what I kind of view in the PSI and the offender's version of, what happened and what to do next and what their goals are, it reads like me. It reads like somebody who isn't thinking about rejoining society for the purpose of helping others or feeling bad about the victims in their cases. To that end, that's why you need specific deterrence in cases like this. If you have an offender where those drivers that we usually rely upon for people to modify their behavior, empathy, consciousness of guilt, just feeling bad for your own actions is how I describe them, those things you hope that get instilled in children at a young age, when those aren't happening, when they've already had all the attempts being on supervision, whether probation or court supervision, where they've had the option of going to treatment centers and having doctors and having agents with them to work on them to accomplish conditions of supervision. When that just fails over and over, that's when you need specific deterrence. That's when somebody isn't being motivated by the carrot, so they need to be motivated by the stick. And this is one of those cases. It also leads me to general deterrence and punishment. As I said previously, this is the third time that Smith has been either convicted criminally or adjudicated delinquent of fleeing. This fleeing involved throwing large objects into the road. One of them was described to me by Deputy Moe as like a metal ramp that sparked as it hit the road. Deputy Moe said that Smith threw it into the middle of the road and he had to make an abrupt movement to avoid it. If he had made a mistake, if he had not reacted quickly enough, one of these objects could have been struck by him or a different police officer at the speeds they were going. They could have died. That's the essence of what the reckless is. The reckless is creating a risk of death or great bodily harm. In this case, it was to a police officer just doing his job, trying to arrest Smith on a warrant that resulted from her own behavior, from not cooperating with supervision over in Minnesota. Smith admitted they were fleeing to avoid consequences and said she was high on meth while fleeing. That reckless conviction exists because the way Smith chose to go about fleeing this time was so much more dangerous than a typical fleeing we see in this county, than her past fleeings. Other people in the public have to be deterred, and quite frankly, the need for punishment is the reason why the recommendation here for a high-end fleeing sentence and a mid-range reckless sentence is being recommended. Because the gravity of this offense, the way the reckless and the fleeing exacerbate each other, aggravate each other, is the reason why. This was a fleeing where the driver's speed was high. It varied between 40 and 69 miles per hour, where Smith would only slow down when throwing objects out of the vehicle. She blew stop signs. She crossed the center line. The vehicle only stopped because Smith disabled it herself while trying to get into the ditch to avoid a spike strip. Smith fled on foot afterwards after the vehicle wouldn't move anymore. Chase was over 10 miles. And it's a chase that endangered the deputies, as I described before, with the throwing of objects. This is not a young first-time offender who made a one-off mistake, who acted outside of character because of some underlying issue that heretofore has never been addressed before and is easily fixed. This is a 25-year-old person who has, despite 13 years of some help, some supervision, some court conditions, has continued to be a risk to the community, has been escalating in the risk to the community with this fleeing, who continues to ignore supervision and rules of courts. The courts have uniformly given Smith up to this point second, third, fourth, eighth chances, and now Smith is asking for a 19th one if you count the adjudications. McCleary-Gallion factors demand more. The character of this offender is such that prison is necessary. Probation would unduly depreciate the seriousness of this offense, and the court should follow the recommendation of 1.5 in, 2 out on the fleeing, and 3 and 4 out on the reckless. Finally, there's one thing I do need to comment on from the sentencing memorandum that I have a serious problem with. The defense sentencing memorandum makes arguments that use the defendant's gender as a basis. That memo argues prison is not safe for transgender people, that prison cannot allow Smith to navigate her gender identity. To that, I have 2 main responses. One, it is ridiculous and without evidence that the Wisconsin prison system cannot accommodate transgender people. It can and it does. The prisons are safe, probably safer than outside the prison because of all the supervision and control of inmates. This is a perpetuation of movie stereotypes that is wrong and harmful. Second, it's illegal for courts to consider gender as a sentencing factor in Wisconsin. It is categorically an improper sentencing factor, just like race or religion. The Supreme Court of Wisconsin explicitly held that gender cannot be considered in State v. Harris, 2010 WI 79. Any argument based upon Smith's gender should be disregarded by this court. It has no application to sentencing in Wisconsin. Thank you.
All right, thank you. Mr. Felisky, before I ask for your argument and recommendation, what is the jail credit?
Thank you, Your Honor. I have the following totals from a review of this file. It appears that initially Josie Smith was brought into custody on May 2nd of 2023, then posted cash bond on May 9th of 2023. She would have 8 days of credit from that time. She was then brought in on a warrant. I believe that was served and executed on January 31st of 2024. I then note here that bond was posted on February 5th of 2024, making for 6 days. Lastly, she has the current period of incarceration that she's been serving from May 26th of this year up until today's date, which would be, by my math, 69 days. So all told, by today's date, she would have 83 days of credit. I've relayed and discussed this with the state, and I believe that is the party's stipulation.
Yes.
Okay, thank you. And it's my understanding that Josie is still on supervision from the latest Minnesota conviction from June.
I believe so, Your Honor.
At least that's what the PSI is stating, and no one corrected me. All right, thank you. Argument and sentencing recommendation, please.
Thank you, Your Honor. I think certainly when we look at this situation, it is quite serious. It would be quite serious if it was a first-time offense. It is certainly serious as it is now. It involves a high-speed chase with law enforcement over several miles, at which point several items were thrown out of the window. It is serious. And I don't think that Josie is under any impression otherwise. In discussing this case with her, Your Honor, and discussing this sentencing, it's been very clear, been made very clear to me that she understands that this is the last stop. There are no further chances that are going to be coming after this. Her record is quite long. It involves serious offenses. It involves offenses of a repeated like nature. She understands that after this point, frankly, since she's been an adult, and arguably before, there are responsibilities towards participating in society that she has not upheld. She's engaged in antisocial behavior and has received punishment to that effect. She has been put on supervision, as has been noted by the state. She has been revoked off that supervision multiple times in Minnesota. In fact, in looking through the packet and looking through the length of this case, it seems there were some significant periods of time in which she was serving out revoked sentences in Minnesota. I say all that, Your Honor, because I think the state's perspective on Ms. Smith is that she's someone that doesn't get it. She's someone that hasn't been able to get it. But in speaking with her and in discussing this case with her, Your Honor, I do believe that thankfully now finally has come the time where she understands that this behavior cannot, should not, and will not continue. She understands and is very open to me about the remorse that she feels for the situation. It's regrettable that it ever got to that point to begin with. But I think looking at that situation, Your Honor, and then looking at Ms. Smith's adult history, I think there is a clear through line here, and that clear through line is substance use. She's advised, and as was outlined in the defendant's memorandum, substance use has been a factor in Josie's life from a very young age. She was exposed to and given substances by people that she should have trusted. And I say should have trusted, Your Honor, because these were not people that she actually should have trusted, but she should have been able to trust them because these were people in her life, authority figures, family, who should have been there to look out for her, to look out for her going on the path that has led her up to this point and acted to steer her away from that. Now, I certainly don't think that that makes for an excuse, Your Honor. I don't think that that justifies what happened here or what has happened in the course of Ms. Smith's life. But I do think when we look at her character, her conduct overall, the reason that she is coming back before the court, that she is having difficulties in adjusting to supervision, the reason that she is getting new court cases is because of this underlying issue. I think thankfully, Your Honor, this last period of incarceration has in some ways been a blessing for Ms. Smith. It has been a period of enforced sobriety for her. It's been a period where she's been able to clear her mind and really understand the gravity of what has happened here, the gravity of what's occurred over the course of her life, in this case so far, and what she needs to do to avoid that going forward. As a member of the Mille Lacs Band in Minnesota, Your Honor, Ms. Smith is, again, in somewhat of a lucky position. She has access through her connection with that community to resources that frankly make the resources that someone else in that community pale in consideration. There's simply more funding, more programming that's available for her as a member of that tribe. So I think looking at the situation overall, Your Honor, looking at the reason why Ms. Smith keeps on coming before the court, the reason why she keeps having these issues in adjusting to supervision is by and large from an inability to address and move forward from an issue with substances, with narcotics. While there is certainly programming available in the state prison system, Your Honor, it, I would say, pales in comparison to what is available and accessible to Ms. Smith when outside of custody. Excuse me. I'd also note that, frankly, in looking at Ms. Smith's history, looking at her connections to this area, to Burnett County in particular, what I have noted and noticed is that she is, by and large, a resident of the state of Minnesota. She has connections in that state. That is where her support network is located. That is where she has built her life, so to speak. I think creating a connection here with Wisconsin, Your Honor, would perhaps be a mistake, given that she has built up this connection, this relationship with her home state, such that presumably the ability to access the resources that she does need to address would simply be much more straightforward. So I think looking at the situation overall, Your Honor, while I do understand the hesitation regarding the history here and the severity of offenses to probation, frankly, I think that, frankly, she's a good candidate because of these underlying needs, because of the fact that she has this clear issue, I would say, with addressing and maintaining her sobriety and proceeding down for recovery. So based on that, Your Honor, what I'm asking the court to do is to sentence Ms. Smith to a period of incarceration in the jail for 110 days, with eligibility for good time, on both counts here, concurrent with each other, consecutive to any other sentence that she may be serving. Thank you.
All right, Josie, I see that you have a paper and it looks like to me you wish to make a statement and you wish to read off of that statement. Is that correct?
Yes, Your Honor.
I'm going to ask you that if you are going to read a statement. First off, Mr. Flisky, please make sure that the microphone is closer to Josie's mouth. Second of all, Josie, please speak loudly, enunciate your words, okay? You need to speak slowly as well because my court reporter needs to take everything down, okay?
Okay.
Also, before you proceed, what is your contact, your relationship with Burnett County?
I have some family here, but not a whole lot. It's on my mom's side, but I don't have much connection to Burnett County.
So family, you mean close family members or just distant family members?
Distant family members.
And so you don't see them very often, if at all?
No,
You have no reason to come into Burnett County?
no,
So if the court were to say no contact with Burnett County, you would not have a problem with that, correct?
no, I would not, Your Honor.
All right, Josie, continue.
Dear Judge Mogan, I'd like to start off by saying how sorry I am for my part in taking so long to realize how much time it's taken to get this case settled. I realized that I've made so many mistakes that I cannot change, but learn from it. I've been so hard on myself, and I know that just because of my past doesn't mean it's too late to change my future. I have so much to live for and do with myself instead of repeating past behaviors. I've learned that no one will or would judge me if I have to ask for help. I've always thought about others. People treated me different if they saw or knew that I needed help. But truth be told, it shouldn't matter to them because they don't know my whole story. And it doesn't matter what they think. I struggle and I struggle, but knowing or by thinking I know how to help myself, I didn't. I know now that maybe it's better if I get help from someone professional, or just maybe I can have the chance to get a better outcome. I've had some time to think of a plan for when I get out. I have plenty of resources and structure and people to stand by me and help me get through this that I didn't realize I had, and I don't have to go through this alone. I also understand that this is a serious and take full accountability for my actions. I didn't intend on hurting anyone, but by my actions, I do see now that I could have, anyone including myself could have been seriously hurt. I don't like knowing that I was the person putting others in danger. I hope you know that I am really sorry for my actions in putting the police officers and myself in danger. I've learned a lesson that by the path I was going down would not end well for me, and that it's not too late to take a better one. As soon as I get out, I also plan on seeking help for my mental health. For my depression, I plan on seeing if there are medications that can help with my mental health. I know that things like medications take time to start working, but I like to start somewhere. I made a few phone calls to get into a program called the RNG Bin Magazine. Provides.
Can you just repeat that, please, and very slowly, because I'm not sure if I'm hearing it correctly, and my court reporter does need to make sure she understands as well.
RNG Bin Magazine. It's spelled ANJ.
I have it. It's a double A too. I'll tell
Okay.
the court reporter how to spell it.
Okay, sorry. It provides sober living, work options, treatment options, and helps with college options. All that can help with my journey on recovery that will be beneficial for me. I'm planning on getting a Rule 25 as soon as I'm released. If I have to cut people out of my life that aren't fit for my journey, then I'm willing to do so. I just want to do right, and I want to prove to myself that I can do it.
Thank you, Josie. Is your address still in Grace Lake Road?
Yes.
Is that a parent's address?
Yes.
All right. Okay. I have reviewed the pre-sentence investigation report and the sentencing memorandum that has been provided by the defense. I have been struggling with this case, Josie, simply because you had your initial case, the 22 CF 120 case, which was serious enough. And then a year and some down the road is when you engaged in this conduct, very serious, dangerous conduct. And you received all of these charges, 10 actually, 8 felonies and 2 misdemeanors from the conduct on May 1st, 2023. The most frustrating part about your case, Josie, not only that you engaged in this kind of conduct to begin with, but there's those underlying issues that the court and other parties can understand, the substance abuse, okay? But the most frustrating part is how you would come to court, then you abscond and go away for a long period of time. Then you'd come back and say, Judge, I'm going to be better. I want to work this out. And then you'd disappear again. And then you'd come back and say, Judge, but really this time I really want to. And then you'd go and you'd disappear again. And this is we're dealing with a 2022 case where it initially started. And the 2023 case, we're dealing with cases that are 4 years, 4 years old that should have been resolved a long time ago. They were way back in the beginning. It's just that something would happen and you would flee or you'd go abscond and you go engage in this other kind of behavior. Lucky for you, you didn't rack up a whole another sheet of crimes. I mean, there's a lot in there from the time that you were charged with our cases. But hopefully you're on your path to figuring it out. Because if you don't, with all of the things that are going on, Josie, both what you're displaying outwardly, but most importantly, what you're feeling and going through inwardly, it's going to destroy you. You have to work through those, and you have to start with going to the healing center, working through your traumas, discussing what you are experiencing and feeling today as Josie. All right. And that kind of situation before you can change yourself. And you did hit it, the hammer right on the nail when you were stating that, you know, maybe I can change the people that I hang around with, and I probably should. Because Josie, you have to change your habits and the things that you do, and you have to change your associates, the people that you hang out with, in order so you can change yourself. You have to be able to do that. That's where you start, changing your habits and the things you do, and changing the people that you give yourself to, you give your time to, your energy to. That's the only way you're going to significantly improve your life. And if you don't modify and make those changes, I hate to see where you're going to be in 5 or 10 years. I hate to see that. The court has to look at the seriousness of the allegations, the nature and gravity of the offenses here. And the court looks at all of the charges that were dismissed and read in, including the charges that you were convicted of, and to see whether or not there's an aggravation there. And there is, with all of these felonies and all of these serious crimes and the conduct that you engaged in, it does aggravate it. I have to look at your character, your past criminal record. I have to look at needs for your rehabilitation and protection of the public. And as Mr. Schmidt touched on, I have to look at this thing called deterrence. So what sentence is going to finally deter Josie from continuing down this path? And what sentence is going to deter others from doing similar things? Because if the court were to look at a lesser sentence, a smaller sentence than what's recommended here, well, let's say a very small sentence. We'll start at the short end of what defense argued, 110 days, concurrent with each other, but consecutive with any other sentence. If the court were to look at a sentence structure that is that small with the actions here, it would unduly depreciate the seriousness of the offense, and it would not deter others from doing this. Because if we look at this, the charges alone that you pled guilty to and you're convicted of, that was extremely serious. Speeding down a roadway, a highway in Burnett County, and throwing things out of the car to try and evade and flee the officers. Where Mr. Schmidt made a very good point that if something were to be thrown out of the vehicle and were to hit the officer's car going at a high rate of speed, anything could happen. The officer could swerve and hit a pedestrian, could hit a different vehicle, could hit a house. The officer could die. Innocent people could have died because of your actions and conduct that day. So that's where the court has to look. Are we looking at a punishment in the lower end, or are we looking at the higher end of a sentencing? This is serious. And it should deter not only you, but it should also deter others from thinking that this conduct and this behavior and doing these things is okay. The court will not look at probation. I have looked at it first, but I will not order probation because, as I stated, it would unduly depreciate the seriousness of the offense. So the court has to determine, is this going to be a straight out jail sentence, or is this a necessary prison sentence where you need more structured supervision and someone else from Minnesota, because you're not from here, so you would be asking to have, through the interstate compact, your probation or extended supervision in Minnesota, but to have somebody else oversee you to make sure you're doing what you need to do. Josie, you're in the driver's seat. You're in control. You have to make those choices and those decisions. You have to. You are at this age where your brain is finally starting to fully develop, and you're starting like an adult. You have to now start thinking clearly. Is this where you want to be in 2 more years, Josie?
No, I
you don't. Is this where you want to be in 5 years or 10 years? Or is this where you want to see your friends or your family in something, in a chair right there,
No, I
waiting
don't.
to determine if you're going to go to prison?
No.
In front of the court, you have appeared that you have a kind and gentle soul, demeanor, but you are letting your internal demons destroy you. You are. I do understand you've had a lot of trauma in your life. I've read it in the black and white, and I've heard some from you throughout these years. You can't let the trauma continue to dictate and to control your life. You have to do that. You do need some kind of treatment. And you do need to take that seriously. But again, only you get to make that choice. I have to look at protecting the public, and here, quite honestly, in my view of protecting the public, it's protecting Burnett County, the residents of Burnett County, and then I guess bleeding over to all of Wisconsin or there. And I know you have connections with Sawyer County, you have connections with Burnett, probably through family in both areas. But I do need to look at protecting the public. And so that's where the juggling comes in of, do I look at a lesser sentence or do I look at all the way to the maximum possible penalty? But I have to look at a sentence that is minimal enough to deter you and to look at the seriousness of the crime without going beyond and being too harsh. Now, in reading the pre-sentence investigation report and hearing the argument of the state, it makes a lot of sense. Look at what you've been doing. You have continued to engage in these serious crimes. You've been to prison. You're not being held accountable. You're not taking responsibility. You continue to let your life be taken over by other people and their choices instead of making your own choices. So a prison sentence makes sense. However, there are other factors here as well. Your attorney did hit on some good things that you are finally in a place where you're realizing that you need to do something, or God forbid, you won't be around if you continue to engage in this type of behavior. Prison would be the least of your concerns. I don't want to see that, Josie. I don't want to see that. So I am looking at the middle ground of a sentence, something that would protect the public. It would address the seriousness of these offenses. It would look at your character and your past criminal needs and look at your need to rehabilitate, all right? And look at you as an individual person. So based upon that, what I am believing is an appropriate sentence. I don't believe that you need to have any continued contact with Burnett County. You don't need to have contact with Wisconsin. You can live your life and do what you need to in Minnesota, but you do need to be punished for your conduct and your behavior involved in this case and the 22 case. So what I am going to do is I'm not sending you to prison. So this is a blessing to you, Josie, right now. It is a blessing because you're going to get the punishment factor and the sanction factor, but you're also going to be able to figure out a life plan and follow that yellow brick road to what it is that you want to see your life be and for you to become. But I do think it is serious enough to sentence you to 1 year of jail, of county jail. Okay, 1 year. There will not be any ability to have the electronic monitor because I don't trust you. Sorry, I don't. And you're shaking your head up and down like
I understand.
it's fair, right?
I understand.
So 1 year in the county jail, that gives you enough time to sit and to think and to figure it out. And it is consecutive to all other sentences. And it is each charge, each count has 1 year of jail concurrent to each other, but consecutive to any other sentence that you would be sitting, okay? $518 in fines and fees. I am also going to do a punishment factor on the financial end of it. $1,982 for each count in a fine. Because you failed to come to court, you failed to take care of this and handle this, and you missed court and absconded and were in custody somewhere else when you shouldn't have been, and the court did not even have to allow you to appear by video. But I believed you, Josie, when you said you want to make these changes and you want to do better. I believe you. But you have to grasp that hard, and you have to take control and ownership of it. I can't want it for you more than you do. Mr. Felisky can't. No one in this courtroom can want it more than you, because you're the one who has to do it. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. That does not include tribal elections. You have to speak with your tribe if you are having an election, whether or not they would permit you to continue to vote. I believe a lesser sentence would unduly depreciate the seriousness of the offense, and it would not protect the public. And it's a punishment portion, I believe that covers everything. Mr. Schmidt, what am I missing? Oh, 89 days of jail credit, 83 days of jail credit. No contact with Burnett. Don't come to Burnett, okay? Because if you're not doing well, I don't want to see you again.
No, plan on.
But I want to know if you're doing well, okay? So, Mr. Schmidt.
A defendant tries to avoid the consequences, but the judge immediately shuts down the excuse and makes it clear that jail is the next step. The tense courtroom moment takes an unexpected turn as the judge delivers a firm warning.